And we're going to continue our arguments this morning with Heter versus Coppinger. It's case number 18CA0047M. Both parties are represented by counsel, so each of you will have 15 minutes to present your argument. Appellant may reserve up to 5 minutes for rebuttal. I'll keep track of however much time you want to reserve and try to keep you appraised of that time. We have read the briefs in this matter. I've read so many briefs, sometimes I forget if there are children involved. If there are children, which I think there were in this case, yeah, we use initials as opposed to names, since we are recorded, and your arguments will be posted on YouTube, our YouTube channel. In case you didn't know, you can watch yourself later on. So with that, we'll start with the appellant. If you'd let me know how much time you'd like to reserve, as I said, I'll try to keep track of that for you.
2 minutes, Your Honor.
2 minutes, okay. I'll let you know when you get close.
Thank you. May it please the court, opposing counsel, my name is Greg Costabile. I'm attorney of record for the appellant and father, Tyler D. Heter, in the matter before this court. This matter comes before this court on an appeal from the Domestic Relations Court with regard specifically to the issue of support. The parties, I should say, were never married, and they had one child born as issue of the marriage, J.H., we'll say, date of birth of 12/7/2010, and the parties came before the Domestic Relations Court with regard to the issues of parenting, custody, and support back in March of 2011. Ultimately, a decision was rendered. There was a shared parenting plan that allowed for equal parenting time between the parties. And the parties mutually agreed to deviate down from child support to an amount of 0. The specific reason, and only reason, that was given for the deviation at the time of the March 2011 order was an equal amount of companionship time between each parent. This is something that the mother appellee confirmed during the trial of this matter, and it's found at transcript number page 52. No subsequent filings were ever made before the court until mother filed a 5-branch motion in October of 2016. Ultimately, the only matter that went before trial was the issue of support. There was a trial held on June 9th of 2017, and the only witnesses were the parties themselves. Ultimately, the magistrate issued a ruling. It was heard before a magistrate on September 6th of 2017. The judge, the lower court, issued an order adopting the magistrate's decision in total on the very same day, but ultimately obviously allowed the parties to object, in which the appellant father did so. Ultimately asked for leave that was granted to supplement his objections once the transcript was complete. Once it was, those are supplemented. Ultimately, on May 18th of 2018, the court again adopted the magistrate's decision in the support going up from 0 to actually an amount of $668, but since there was so much time in between with the arrears that had accumulated, there's a 20% penalty put on, so it was actually over $720 per month, over $8,400, almost $8,500 per year. That was not in case just 5 years ago. We come before the court on 3 different issues that are under appeal. And we certainly understand, and both parties agree, as the court obviously saw from the briefs, that when reviewing a trial court's action involving a magistrate's decision, an abuse of discretion standard is applied, is obviously adopted by this court's previous hearing in Field versus Cloyd in 2008. The abuse of discretion standard counts more than error of judgment, which we understand. It implies that the court's attitude is unreasonable, arbitrary, or unconscionable, as the Supreme Court determined in Blakemore. Again, both parties agree with those standards. And we truly believe, Your Honors, that in this matter, the lower court's decision was arbitrary, unconscionable, and unreasonable. And we say that for a number of reasons. We start with our first appeal, or our first assignment of error, I should say, that the court abused its discretion when it failed to simply dismiss the appellee's motion for support. And we say that because when a support order is to be modified pursuant to 311979A and C, which are to be read in conjunction with one another, there not only has to be at least a 10% difference in the support, but there also has to be a substantial change of circumstances that was not contemplated at the time of the previous order. Now, this honorable court in previous decisions has upheld that and also went on further to give a lower court guidance on how to handle these matters. Not only in the matter of Greathouse versus Hilliard in 2017, but Hill versus Hill in 16 and Sifferlin versus Sifferlin in 14. The courts in all three of those cases determined that when parties previously agreed to deviate, the moving party must show more than a 10% deviation to demonstrate the required change in circumstance and must show substantial change in circumstance not contemplated when agreed to in the deviation. Further, in Greathouse, which the facts, and I'll just say, are maybe somewhat similar to the briefs that we had before the court. In Greathouse, there was no proof to show any change, and the Greathouse court ultimately said that a legal counsel cannot give evidence that was not found at trial. And I think if we look at the briefs that were presented before the court, you'll see in the appellant's brief, there are proper citations to the trial transcript for each and every fact that's alleged. In the appellee's brief, you don't see that. You see comments that are made that are not substantiated by the trial transcript. And so those statements should not be taken into consideration by this court. What are one of the statements? Well, we actually have two different arguments from the lower court as to what was the substantial change in circumstance not contemplated. Initially, the magistrate said it's because the parties were living together at the time of the previous order and no longer are. Well, the shared parenting plan clearly lists that the parties had separate residences at that time. And ultimately, the trial court, even though it adopted the magistrate's decision, ultimately said we agree. And if you look to it, there was no change there. The parties were living separate and apart at that time as well. Even though the mother may have testified to that, there was no corroborating evidence, and nothing ever supported that, and all you need to look is at the shared parenting plan. So ultimately, when you look at what the court, the lower court finally decided, the court said the substantial change is 5 years since the lat order, and respectfully, I don't believe there's any relevance as to the amount of time between orders. I haven't seen any case that supports whether it's 1 year, 2 years, 17 years. The next thing that the court said is the father earning more money, and now this just goes back again to the 10% change. And we already previously established, as well held in this district, that just a 10% change is not enough. You have to show something more. The final reason the court gave is mother's married with 2 children. So those are the 3 years. 5 year difference, father's making more, and mother's now married with 2 children. Well, which we'll get into in our later 2 assignments of error. What the court neglected to do is bring into consideration as to the household income in mother's home. So at the time of the actual, and if I'm saying divorce, I apologize, sometimes I do that, but at the time of the previous order, March of 2011, it was established that you could look to the worksheet, the difference in household income was only $3,000. Now, in the most recent case, the difference in household income, because mother established at transcript 46, that her current husband pays all of the support for her 2 kids, all of it. And that's said, that's unchanged, both parties agree with that. And in fact, when you look at the amount of money, there's $60,000 worth of household income into mother's home with her new husband. There's only a $3,000 change in disparity between income from the time of the 2011 order until the present order. So even though just income alone isn't enough, when the court said that they're also looking at mothers now married with 2 children, well, the very next step, which should have been in there, is what else is in the household? What is that next step so that a reviewing court can see? Well, the transcript dictates what it is, but the lower court didn't state what it is. So if you look at the precedent cases that I referenced, you also see the facts actually in Zifferlin were very similar to the case of Bart. Where in Zifferlin, even though the amount of time between the parties had slightly changed from the previous order, Zifferlin court didn't believe that there should be any change. And second, actually in Zifferlin, the obligor was making $12,000 more than what he was making at the time of the previous order. So it's similar in nature in the case, and the precedent still holds that you have to have more than a 10% change in income. And the only issues that the court relies on to say this is the significant income change in circumstance not contemplated are years and mother's statement, which we just alluded to, which would be inappropriate. In light of that, we truly believe that that decision of the lower court is arbitrary, unconscionable, and unreasonable, and as a result, we ask this court that they just straight up dismiss mother's motion for modification of child support because it doesn't reach the dictates that this court has very clearly laid out for lower courts.
Counsel, when you're talking about, the three things that the court relied on as a substantial change of circumstances, the father earns more money, the length of time from the last order, and mother married with 2 children, and you said, well, the expenses for those 2 children are paid by her current husband. But isn't that really getting more into the merits? If we're just looking at a substantial change of circumstances, wouldn't that be a substantial change of circumstances that mother now has 2 children?
Only presumably, Your Honor, until that can be rebutted, and I cannot believe it can be rebutted if a court takes then the next look. What does that mean? You would look that the statute and the courts are set up that if somebody now has 2 additional children, which could bring on a more greater burden to that person, what's the next step? Is there any other support coming in? Or does that person now have a greater burden because there are 2 other mouths to feed and clothe and house with no other support?
And you see, I understand what you're arguing, but I'm just not sure that wouldn't go to whether or not there would be a change in the amount of support, whether it be modified. In other words, you're saying you don't even get in the door, and I'm wondering if you get in the door, you just may not get your modification.
Well, the reason I say you don't get in the door respectfully, Your Honor, is because, yes, a lot of our assignments of error are interchangeable, I see that. But a court just can't have a blind eye to other facts. If you're a trier of fact and you're bringing in all the facts, you have to see all the facts that were presented. And if part of those facts is that there is no disparity in the income between a household, is only $3,000, well, that goes right in line of what we were saying with Zifferlin, Greathouse, and Hill. That if the parties previously agreed to deviate down to 0, you better show something that they never contemplated before. And the only thing that you see that the appellee brings up is that, well, father was in an apprenticeship program and now he's not, now he's making more money. Well, I don't know. I would imagine if you're in an apprenticeship program, eventually you're going to get the job you're in the program for. So I don't know why that could possibly be something that was not contemplated. So based on those, and I think the well-founded cases that I referenced, we believe that that motion should have been just dismissed outright. In the alternative, however, if this court believes that they somehow met their initial burden, if you will, to have these other issues read, well then certainly the court was required to follow the dictates of Revised Code 3119, 22, 23, and 24 when we deal with potential deviations. And the only thing that's mentioned in the lower court's decision very specifically says that since the magistrate determined that there should be no deviation, the lower court believes that it doesn't have to look at any of the factors. Now, respectfully, if a court's going to make a decision and say no deviation, and a reviewing court has to have the opportunity to review the rationale that the court used, if the lower court is saying that we don't have to give it to the reviewing court, to me that's the definition of arbitrary. They're coming out and just making a blanket statement that we hereby determine that there's no need for deviation. And when you look to, well, what's the reason for that to support your rationale, we're not giving it to you and we don't have to.
I'm going to pause right now, just to let you know your total time left is 2 minutes and 30 seconds.
Thank you.
Okay.
So under those dictates, and also found with this court's decisions in Hock versus Carr in 2012, as well as Freilich versus Parrish in 2016. In Hock versus Carr, court must consider factors in section 3119.24. I mean, it's about as straightforward as you can get. Every case you see, this court has to be able to see why did they determine that a deviation wouldn't be reasonable. Instead of just a blanket statement that we hereby find it, they have to give some support, as this court has previously provided, and they failed to do it. And in the present case, it's almost identical to Freilich versus Parrish, where the father here has 43% of the time. They did in Freilich. Ultimately, Freilich determined that that should have been grounds enough, just on that, without any of the other factors. And this court did not do it and didn't give any reason why it didn't do it. Finally, we looked at 3119.05c. We think that the court misapplied that section. That section allows for a benefit to a person who has children from another marriage, as long as they're not receiving support that goes beyond the federal exemption. As I alluded to earlier, at trial transcript 46, Mother clearly states that her new husband provides all of the support, not part of it, not 10%, not 80%, 100% of the support with the new children. There is no extra amount of money to mother whatsoever. And even though that was clearly stated and in the transcript, the court simply neglected it. Now, even if a court wants to say that it has to be a child support order, I have found no cases that specifically state that, but even if this court wants to state that that's the case, well then you most certainly have to get to the deviation factors of the worksheet, where it would go beyond what the legislature clearly intended, that if you're only going to give a break to somebody with extra kids, up to the federal exemption, if you are receiving no support. If you're receiving support to completely cover it, and let's assume line 8 of the worksheet goes in as the lower court did, well then you most certainly have to give some type of credit back or deviation later, knowing that all of that has been covered by the new spouse. So in light of the statute and the precedent that we provided today, we request that the court dismiss mother's motion, reverse the lower court decision dismissing mother's motion for support, or in the alternative, if this court believes that it should have been heard, there should be a proper deviation applied. We ask that it be remanded to the court with those instructions as well. Thank you.
All right, counsel, you've got 3 seconds left for rebuttal, so I assume you used your whole.
Oh, when you said 2 minutes, I'm sorry, Aaron, I thought that meant 2 minutes of my 13.
Total time, no.
Oh, I misunderstood you, otherwise I would.
All right, well, think carefully because you've got 3 seconds. All right, counsel, you have 15 minutes.
And I made the mistake of closing my computer as I came here. There we go.
Let me get fired up.
May it please the court, my name is Leslie Grasky, and I'm here on behalf of Nicole Bart, formerly known as Nicole Coppinger. I noticed that I am missing a transcript reference in my statement of facts. If the court would like, I can look that up while I'm here and submit it separately. However, the statement I'm talking about is the unrebutted evidence was that the 2 parents, teenagers, were living with her parents and then his parents. And that's why we have 2 addresses. One was his daddy and mom's address, and one was her daddy and mom's address. But they were living with the parents back and forth. That changed when they grew apart. Another thing that changed is he started and completed an apprenticeship program. He was not in that at the time they were teenage parents. My client married and had 2 children. That is another change in circumstances. His income increased, not just incrementally. There was a reference in his brief to $3,000 per year. Well, that is possibly the rate. However, during those years, he didn't pay a cent in child support. Ms. Bart did not seek or even an administrative review during any of that time. She waited until there were these substantial changes in circumstances which justify the trial court in finding that child support should be awarded. The trial court correctly calculated child support based on the child support worksheet, and it used the figure that the parties agreed should be imputed to mother for her income, about $22,000. She did not actually work earning $22,000 because she has 2 small children, and by the time she paid the child care for that, she really wouldn't be bringing in any money, but she knew it was fair to agree that she could earn $22,000. That's why the trial court used that figure. So yes, she does rely on her husband to maintain the household, but there is absolutely no authority that her new husband has a child support obligation that should be that would justify his income being incorporated here.
Counsel, let me just ask you with that. I'm sorry. I'm sorry. Let me just ask you before I forget. I mean, I understand what you're saying, but I also was wondering if the situation were different. You know, how we love these hypotheticals, we judges. And if the wife, if the mother here had been married, had 2 children, in addition to the child she had with the appellant here, and then she divorced the the guy that she was married to, and he had to pay child support, that would be included, wouldn't it?
It would. It
So
is
why is it not included with the husband?
primarily because this court has never made a change based on that. It's never found that the new husband's incidental provision of room and board and all those expenses is included. There is a raft of litigation every day in the domestic relations court, and unless the party has married a millionaire, it is not considered, because the statute actually represented benefits of remarriage. That was the original language, and that has been how the courts have applied that. If this court says that we're going to use equalization of households, then first of all, if that was the argument Mr. Heter was going to rely on, then he should have brought in the income of his fiancée with whom he lived, because that's another aspect of household income. That's not what he was relying on. He was relying on there was no change in circumstances. The fact that she is staying at home and not earning $22,000 and paying almost that much in child care expenses, I think figured into what the trial court was looking at. That it's not practical to go out and work just to pay a child care bill that would not have been in the best interest of any of these children, including the child at issue in this matter. I think that's part of the thought process that was going on. There is definitely evidence in the record that the parties were living together at the time. Mr. Heter hired a lawyer and got a shared parenting plan, and Ms. Coppinger did not have counsel at that time. Dad would like this court to consider that deviation is mandatory, and it's not. It is something that the court may do when it determines it is appropriate. This is a court of equity. The court heard all of the evidence, including all that led up to the final hearing on child support. This started as a motion just to get the insurance card for the child, because Ms. Bart was having to fight with every medical care provider because he wouldn't even give her the card. That got resolved, but that was probably in the trial court's mind when the magistrate made her magistrate's decision. Ms. Bart wanted to move 10 minutes from Dad's home, but it would just be outside of the Medina County line. That couldn't possibly happen, so she withdrew it. She asked that the court incorporate a parenting time order that would actually reflect what they were doing. That was much travail. Everything that had to happen here was so difficult, and we had to go to so many hearings, and we had to put on a significant trial just to establish that these two teen parents had had many changes in their lives, and that it was now time for Mr. Heter to contribute to the support of his child. If the court had decided it wanted to deviate, then it would need to go through those factors, and that's really the obverse of what is being argued in this matter. It's not mandated that you do deviation. If you do deviation, it is mandated that you follow the statutory constriction.
Let me ask you
Finally-
this. You made a statement, and I'm not trying to be picky, but
Sorry.
but you made the statement, it is now time for him to contribute to the support of his child.
Yes,
Didn't he have the child like 43% of the time?
he does.
Well, isn't that contributing to the support of the child?
It's some, but the concept, the policy behind there being child support, even when there are shared parenting plans or substantial timeshares, is that you don't have a rich house and a poor house. For the last at least 3 years, this child has had a wonderful financial setting at Dad's house, and an okay one at Mom's, no harm, but that's what I guess I may have overspoken, and I appreciate your calling that to my attention, but the child support statute is intended for the best interest of the child, and the child is best served by an appropriate child support order that puts her in the same ballpark in both homes, not one house that's good and wealthy and one house that's okay.
Isn't it that the statute puts the child in the same position that the child would have been in had the parties?
Stay together.
that would speak to the standard of living of the household when the parties were married, wouldn't it? Not prospectively into the never-ending future.
Well, actually, I don't think it's trying to go forward. I thought it was saying to give the child equity. The parents' incomes grow as they grow. That's my understanding, is that what would the child have if the parties had stayed together? And the child would have benefited across the board from dad's increased income, not only at his house. That's my understanding of the policy, is you're looking at the child's best interest, not only dad's best.
But the trial court never actually reached any of that analysis, did it? It just said because the magistrate did not recommend father's child support be deviated from, we don't have to look at those factors.
And I believe that is the case law, is that you don't have to deviate. There is no law on a mandate of deviation. But if the 3113-215B6 does not provide for an automatic credit in child support obligations, which is poly, it says if you do this, then these are the steps you have to go through to justify it. I think the court determined it was not equitable here and just did not make that next step. I don't think the statute requires you to go through those elements. We have a new statute now, which is significantly different, and I think under statutory construction, that alone demonstrates that the court was trying to do something different from what it did before. Finally, Ms. Bart's husband does not have a specific child support obligation for this child he is providing, and that's sort of taking the place of her imputed income, which she does not actually receive. This child is receiving the benefit of all the income that is in mother's household. Father did not come in with his theory of the case being, let's look at both households' income, because he didn't bring in any income of his fiance. It is appropriate to respect the lower court's decision when it has addressed all of the statutory provisions. And specifically, I'd like to note that Sifferland was important because although there were changes in circumstances, they weren't changes that warranted father's increased child support. That's paragraph 20. I know that case. Great House, there was no evidence. There was no sworn testimony as to the facts. That decision, that trial was conducted right at the time of the Stearns decision, when, at least in Summit County, people were doing cases entirely on statements of counsel. Stearns changed that, but Great House was done at that time, and this court properly, I believe, applied Stearns because it shouldn't be done on statements of counsel. But what the court was talking about in Stearns was at trial, relying on statements of counsel. This court will find in that transcript evidence to support every point. And again, if I can have a few moments with the transcript, I can insert the 2 pages that I was remiss in not including. I have other transcript references, so I did read it. I just missed 2 to put in my brief. We would ask that this court affirm the decision of the lower court. Thank you.
All right, thank you very much. You've only got 3 seconds. I'm assuming you've got nothing further to say here.
I would, before you click that, I would just ask the court to follow Great House and disregard facts not supported by the transcript. And when you hear this is what we think the lower court did, that's our whole reason. We don't know, and that's why we ask that you overturn the decision. Thank you.
Good use of your time. 3 seconds. All right, we'll take the matter under advisement. The court will issue its decision. Each of you will be sent a copy of the court's decision on the day it's released. You can also locate them on the Supreme Court of Ohio's website. Thank you both for your arguments today.
Thank you.